Mom's on Medicaid. Mom's going to receive an inheritance of $80,000. It's going to knock her off of Medicaid, isn't it? What do we do? And he said, I know what we'll do. We'll disclaim the inheritance so she doesn't inherit it. We'll let it go to a trust over here that somebody else will be in charge of, and they can use those funds to help Mom if she needs supplemental help. Okay, sounds great. Except that if you disclaim something, that means you had authority over it to disclaim it. And Medicaid says, well, if you had authority over it to disclaim it, you made a transfer for less than full value. Okay, so basically the entire $80,000, she's going to be penalized and knocked off Medicaid paying for several months. So this attorney, who acted like he knew what he was doing and seemed like he knew what he was doing, gave her terrible advice. And I said on Facebook, I need to do a workshop. I'm Mark Galloway. I'll tell you a little bit about myself. I started practice of law in 2003. I went to law school because I wanted to help people. And my idea was, I'm going to go to law school, and then I'm going to go into the FBI. Then I'll have a bunch of knowledge, and I'll have authority, and I can help people and get bad guys. Then I was in law school for a little bit, and I thought, well, you know what? Maybe I'll just become a constitutional scholar and save the world that way. Okay. And then as I got into things, I thought, the government's going to take how much in estate taxes? Oh, I want to stop this. And that's what I fell in love with. Don't have to worry about the estate taxes anymore, really. If you have to worry about the estate taxes, we need to be friends. Because right now you don't have to worry about the estate taxes unless you're over $12.92 million in assets. I really liked all the little things you could do. Okay, and the practice of law was a very academic pursuit to me initially. I worked for Kansas Legal Services for a little bit, but then I got back into estate planning. I became the managing partner for a firm in Topeka, opened a satellite office for him out here. A friend of mine, whose plan I had done, who then got divorced from his wife, I did a joint plan for them. She was dying of cancer, but he still moved in to the house and lived in the basement and helped take care of her, and she died. When she died, I found out the plan had not been maintained. It was not going to work the way it was supposed to be working. I took them to a probate attorney, and he said, well, I think it's going to take this many hours. I'll take a $7,000 retainer to start. And that crushed me. I cared about these people, and their plan didn't work. You know, if we'd been able to stay on top of it, if I'd been practicing and knew what was going on, I could have saved them a lot. And it's not just the money. The drama that went on with her dad, who was expecting all this stuff, drove up from whatever state he was living in and drove the car home that didn't belong to him. You know, it's a big mess. And we could have avoided all the mess and all the drama. And that, in my opinion, is where the big costs are, way more than the money. And that's what I'm in it for. Let me talk about some of the stuff I'll cover, and you can tell me whether you want me to cover it or not, okay? And then, if there's other things you want me to cover, I'll take notes, and we'll cover those too. Okay, first, question, can I protect my stuff from the government, long-term care, and family, and how can I do that? Sounds like something I should cover? Okay. What's a trust? What's the difference between a revocable trust and an irrevocable trust? Something I should cover? Yes. I saw the head bob a little bit. Okay. They're very enthusiastic. This side is lacking. Okay. What? Okay. How can I avoid probate? And do I need to? Can I or should I give my stuff to my kids or to others? Okay, good question. Okay, I'm going to make the first absurd statement of the night. If you love somebody, you never give anything to them ever. Okay? I'll explain. You're going to agree with me by the end of this. I promise. Except little gifts, That's okay. That's okay. Sorry. So not anything ever. I know you have kids. You can give your kids gifts. All right. If I give my stuff away, will it take 60 months for it to be safe? Who's heard something about that? Anybody? No. That deals the long-term care expenses. This is a Medicaid issue. We'll talk about it. What is a power of attorney? A living will, healthcare proxy. What's the difference? Do I need them? The answer is yes. Okay, we'll talk about those. How can I plan for disabled beneficiaries? Interested? How many people have disabled beneficiaries? It's a good question.
Maybe I need to know.
Okay, you don't know. At this point, you cannot know. Here's a test, all right? This is called the two-finger test. Do this. If you hear a little bump, if you feel a little bumping sensation, you're alive.
Okay.
You do not have beneficiaries. You don't know who's going to be disabled when you die. Okay. If they're in the same car crash with you, they may very well be disabled. So we need to consider how we plan for them when you're not able to say anything anymore. Okay. Are my IRAs safe? Yeah, we'll talk about that. But okay, how can I avoid estate taxes? Yes, you're safe from estate taxes because you don't have enough money. We've already talked. Yeah. If you do, again, we'll talk after privately. Okay, those are the things that I'm going to cover for you. So the goals of this workshop will look at whether or not you're all set. Does what you have meet your needs? Okay. We'll try to understand what it takes to protect your stuff and show you how to get what's missing, if you're missing anything. The 3 steps are: know the rules, know your predators. We'll get to that, what it means. Okay. That's basically know who or what is coming after your stuff, or can, potentially. And then know what the options are to overcome those potential problems. So first, know the rules. Well, there's different sets of rules. Okay, which way is Topeka? That way, right? They have a set of rules for you already. It's free in the statutes, okay? If you don't do anything, they've got your back. They've got you all everything all figured out for you. If you die without any type of planning, KSA 59 says, this is how we're going to take care of you, running you through what's called an intestate probate, where the court's in charge of what happens to everything. Everybody has to have authority to take care of stuff, right? Most of the time, you're taking care of your own stuff. But what happens when you can't? Like, Dale is gone, so he couldn't. So, actually, when my wife went into the military, I was power of attorney for her. Again, I'm power of attorney for her, but not because she's in the military. It's because she can't take care of her stuff right now. So I do. Okay, question, what type of power of attorney do you have? There's a lot of different options, right? Most people end up with whatever the statutory power of attorney is. It's whatever's in the statute, that's what I got. Okay? That is great until it's not. We'll get into that. Okay. What about a healthcare proxy? In Kansas, this is also called a power of attorney. It's a durable power of attorney for healthcare decisions. Okay, what's that? The normal power of attorney is restricted from, the agent under that power of attorney is restricted from making any healthcare decisions on your behalf. You have to have a separate power of attorney to do that. So you go out to eat, you both stand up, you're walking out of the restaurant, one of you has an embolism and falls. The doctor says, do we operate? You know, your financial power of attorney won't handle that. You have to have agency under a healthcare power of attorney to be able to handle that. And if you don't have one, then you've got to go to the court and try to, well, the court can't give you the power of attorney. What you have to petition the court for is guardianship or conservatorship. And until then, the doctors are going to make their own decisions. They have to, okay? Until they find somebody who has authority to make those decisions. If you have a last will and testament, who's in control when you die? Anyone? Whoever you've got in there, okay. After you go to the court and the court says, and they're able to validate that this is your will, first of all, and then the court appoints who you've nominated, usually. Okay, so yes, that person then is in control. Who gets your stuff, the beneficiaries under your will, and so this is what's called probate. And the court is in charge of making sure that things go the way they want to. Who thinks if I have a will, it's going to go the way I want it to in my will? Then why do people use them? Okay. Now, okay. I'm going to tell you a little story. I was having a conversation. An attorney, he does wills, he does probate. He's got a doozy going on right now. It's been going on for, I won't tell you the number of years so you can't identify it, but a number of years. And child dies, disinherits his brother, but everything goes to the parents in his will now, but they died. So now, through the descent statutes, it goes from them to their children, which includes his brother. His brother's dead, but he has kids. So they're arguing about, does it go to these kids? Okay, that's a little piece. Here's the worst one. Some girl from some other town far, far away says, that was my daddy. There's $300,000. They can't prove it, but there's enough evidence to make the judge stop and say, yeah, maybe you guys ought to talk and work something out and give her something. And they're talking about giving her 1/3. Because that's my daddy. A totally separate girl says, this man had an affair and I'm his child. And did you hear how long? I said years this has been going on, and they still haven't distributed anything, right? So maybe not the best way to plan. But so why do people do it?
Because it gives them a sense of security.
It's cheap too, right? They think it's cheap.
You can download one on the internet.
Yeah, I can do it for free, right? So, but then where are the costs? In the courts, okay, yeah. You imagine the actual heir and what they've been going through for years. And everybody has attorneys. So there's the emotional cost, and then there's the financial cost on top of that. Yeah, so the wills, not the best way. What you're doing is you're putting off the pain, okay? I don't have to deal with the pain. I'm going to make my family deal with it. Wills are not the best the best way to plan. Okay? There's better. So let's talk a little bit about powers of attorney. What happens if I give you a blank check? What can you take from me?
Everything.
No!
Not if you don't have a power of attorney.
You can take what's in my account, right? Now, if I give you a power of attorney, what can you take from me? My house, my car, my IRA. It gives you authority to take a lot of stuff, okay? Okay, so that's one problem with powers of attorney. What's another problem? Okay, so right now, you're not dead, you're just in a coma, all right? So that's better. She comes into my office and she says, I want to plan for him. And I say, great. What kind of a power of attorney you have? Oh, the regular one. Now, let me see it. Well, guess what? It doesn't give you the authority to plan for him, to protect his assets when he goes into a long-term care facility. It doesn't give you the authority. So we got problems. One, it's too much authority in some circumstances. In other circumstances, it's not enough. So what do you do? Well, what you do is you say, I want you to have every authority that you need. Well, I just made a super blank check. That's what a lot of attorneys will do that aren't really estate planning attorneys. They'll just throw in, here's a general grant of authority. You can do whatever I could have done, plus any possible authority anybody's ever dreamed of, I'm going to say you can have. So now, not only do you have the authority to take everything, but you have the authority to take everything in exclusion of anybody else who should have been a beneficiary. That's not a good result. So what do we do? What do we do is really simple. We say, okay, here's a power of attorney. Here's all the possible authority that you need, but here's instructions on how you can use the authority. Okay? It's only going to be for me. It's only going to be in line with my estate planning goals. There's the marketing part, right? Where I just said, I'm brilliant, and if you don't come to me, your life is lost. Okay, there are a bunch of really great attorneys out there. There are attorneys in estate planning who've probably forgotten more than I will learn. Well, maybe not quite that much, but who know more than I do. And they're wonderful. You just have to be sure that whoever you're working with is one of those guys, or me. Okay? So, so I'm going to tell you, I'm going to pull back the curtain a little bit on the estate planning industry, all right? Do you think when I work on this stuff that you come in and you talk with me and I take notes and then I sit down on my computer and I just start typing madly? No, these are way too complex. I charge $350 an hour. If I did that, you would be broke before I got halfway through your documents, okay? What we do is we use very sophisticated software that's created for attorneys who know what they're doing to get a baseline document which then we can customize for anything that's outside of the capabilities of the software, okay? There are like 5 major groups. About 2 weeks ago, I was hired by an out-of-state attorney to analyze a trust. And I started reading through the trust because the clients were coming into his office. He said, they're coming into the office in about an hour, and what do I say to them as far as what we need to do to update their trust, or do they need a new one? So I'm reading through, and I say, this is a pretty good trust. It looks like everything is in order. I don't know what their specific, wait a second. They just gave everything to their one beneficiary here, but in the very next section, outright, free of trust, just gave it to her, which remember, I said, if you love somebody, you don't ever do that, right? And then in the very next section, they create a trust for her. But the money's gone. You know what that tells me? That tells me somebody who was acting like he knew what he was doing, who didn't know what he was doing, had a fancy software program, and sold his services to a client. Here's the part that kills me. Most of the time, that client who paid for the product will believe they have a good product until they die. Their family finds out they didn't. He had a great software program, he just didn't know how to use it. When I first started out, my mentor told me, if you use this software program, you will never commit malpractice. I'm telling you, that is not necessarily true. I just recently was hired to analyze another trust. Son made a trust. He's never been married, never had kids, goes all to mom. Okay? Son is in a bad way. They sell his house. The money comes to the trust, but before it comes to the trust, he dies. Supposed to go all to mom, right? And she's supposed to be the successor trustee. Okay? That's the person who manages the trust. Guess what? Mom's in a memory care facility. She can't do it. They have a backup successor trustee. Yay for them. Who is it? It's a bank. They don't want to do it because there's not enough money. It's just not enough for them. They don't want it. So what are we left to do? Go to court. Now, if they had put a trust protector, that's a fancy new thing you didn't know about before, into the trust, then the trust protector could have said, daughter, see, that's who came to the attorney to begin with. Daughter comes to the attorney and says, hey, what do? I want this money to be able to pay for mom's memory care facility. And it's supposed to be hers. How do I get it? The trust protector could have said, bing, daughter, you are now the trustee. That would have fixed it. But they didn't have that. They had, and it was a big firm too, guys. But they had, really pretty document folded in thirds. Looks super important. Okay? But it's only about that thick. If you've got enough provisions in there to be able to cover everything you need to cover, it grows. Theirs was very, very lacking. Sometimes you have just a document and it's not part of an overall plan that's holistic, where you've kind of integrated everything together. And may work, may not. Here's a really good example of that. You go to financial advisors, you go to attorneys who do wills, okay? And they'll say, just do a transfer on death, do a beneficiary designation, do joint tenancy with right of survivorship, and make sure all of your assets are going this way, and then you stay out of probate. Your will's just a backup. Go to your bank and say, upon my death, this transfers to this child. And my car transfers to this child, and my house to these two kids. Okay, so, we'll get into why that's bad. Except for you can see, maybe these values change, and things are not nice and even, but there's much bigger reasons that that's not the best way to do it. So now we get to knowing your predators. Like I said, this is who's coming after your stuff. All right, if you're choosing the government's plan, then guardianship is what's going to happen. That's going to cost you money. Probate's going to cost you money. He throws in taxes, but you guys are all under 12.92 million. So, but the government's program will cost your estate quite a bit. So how do you avoid that? How do you stay out of probate and keep from needing to have a guardianship proceedings? Okay, I'm going to talk about guardianship proceedings real quick. So you think of a guardianship proceeding going really smoothly because the person, got hit by a car and they're in a coma and you need guardianship. My experience is not that simple. Most of the guardianship proceedings that I was part of was because something happened in that person's mind and they thought that they were fine. And they will fight it tooth and nail. And so it's a little pricey. And not just financially. It's pricey emotionally. So maybe not the best way, but actually in some circumstances, no matter what documents you do, you'll end up there. So remember I talked about my friend, when he went off the rails, they put him in a hospital, and I had to help her remove him as trustee because from the hospital he was calling up his broker and saying, I want to liquidate all this stuff because I have a great idea for a new investment. Okay? That guy needs a guardian if we don't have other things in place to stop him. We had other things in place to stop him. The living will is what? Who knows? The living will, as it's been termed, okay, who remembers the Terri Schiavo case? You remember the Terri Schiavo case. Terri Schiavo, blink twice if you see the red balloon. No? Okay, so I won't go into it. Terri Schiavo was a case from a way back where the husband fought against the parents when his wife was in a coma. And she didn't have anything saying what she wanted. They said she would have wanted to have all heroic measures to keep her alive. He said she would not want to live this way. She would want to be let go. And they said, you just want the life insurance. So it was a big, big thing. But if she had said, I don't want to be kept alive by invasive means, just in some document, that's the living will. It's the unplug me document. Do not resuscitate is a little different. Do not resuscitate in Kansas is something you fill out, and if you are now laying on the ground and you need CPR and they see that in your glove box you have a DNR, do not resuscitate order, they are not allowed to resuscitate you, even though they could. Okay. My friend who got divorced and his wife had cancer, she had been through cancer once prior, and she had a DNR because if she ever went down again, she didn't want to fight through it again. So that brings up another thing. Where do you find living wills and healthcare powers of attorney most in the United States? When you go to the hospital. For any surgery, they say, do you have this? Do you have this? Okay, how would you feel if I offered to write you prescriptions? I would diagnose you, I would give you prescriptions. That would be silly, right? Because I don't, well, you don't know if I know anything or not. No, but I don't. Why would you go to a hospital for your legal documents? But if you want to get it done right, then go to somebody who knows to get it done, how to get it done right. How to counsel with you and get what it is that you want and need. Okay. Before we go on, I'll tell you the way I do estate planning stuff, I don't charge hourly. I teach you, like I'm teaching you here, I teach my clients. Then I say, okay, if you want this plan, you tell me out of these things, now that you've learned what there is to learn, what's important to you. If you do these things, it'll cover these things that you thought were important. If you do these things, it'll cover this amount of what you thought was important. If you want to cover everything that you thought was important, it's this, and then there's stuff beyond that also. So that's how I teach you, I show you what's there, here's the prices, choose what you want. All right, so long-term care costs. These are figures from New York in 2016. If you're looking at the nursing home costs right now, average statewide in Kansas is way lower than that. Average statewide is $6,425 a month. How do I know that? Because that is the Medicaid penalty divisor. For every $6,425 a month you give away, Medicaid will penalize you 1 month that they won't pay after you've qualified. So in a year's time, that's $77,000. And that's nationwide, that's cheap. My buddy in Idaho, who I'm helping with his practice, they're almost at $10,000 a month. So, but even at this rate, I say even, and I'm pointing up there like you can see the 6,000, it's not there. Even at the $6,000 and, well, $6,500 a month, that adds up really quick. And so you can see, so let's go back to that case I told you about that was all messed up, where son died, gave the stuff to the mom, but the mom can't take care of it because she's in a memory care facility. And daughter wants access to it to pay for her care. This is where I'm saying, again, it's a little bit twisted off of that, but the same kind of idea. If you love somebody, you don't give them stuff. Now, if mom, the trust actually said mom gets it outright, unless she's incompetent. And she was. So then it stays in trust. Hallelujah, he had that provision in there. Okay? Because now what can we do? Instead of daughter burning through the whole amount of money from the sale of the home, which would be gone in 2 years, and then having to apply for Medicaid, and there's nothing left for mom's care, for mom's quality of life expenses, what if she wants to go to see family at Christmas? What's going to pay for that? What if she needs or wants a therapist that Medicaid won't cover? What if she wants somebody to come in and take care of her diabetic nails? Okay? We can take that money and set it aside. We can protect at least a portion of it, if not all of it, and get mom qualified for Medicaid today, and date that back to the beginning of the month. And then Medicaid will pay for the $6,500 a month, and we've got another $100,000 over here or more that can pay for all of the extras. What if we need to buy a car so we can take mom places? What if she wants to get outside once a month or, more, wants to go out to eat with her kids? These, all those little, I want to maintain my integrity things. So that's the better way to do it. So we were talking about Medicaid. Have you heard that they can take your home? Yeah. Have you heard that you have to give your assets away to keep them safe from Medicaid? A lot of people have heard that. Okay, well, have you heard that if you have, we talked about this at the beginning and you guys hadn't heard about it. But, so the answer, by the way, is no to all of these. This 60-month thing here comes from Medicaid has what they call a look-back period. And they look back 5 years to see anything that you gave away.
Does that include things like to church? Donations?
Yes, it does. Yeah, okay, and they'll argue, you gave that away to qualify for Medicaid earlier. We think you should have been holding on to that to pay for your Medicaid expenses. And then you might fight them and say, No, you don't want to have to fight them on stuff, but sometimes you do. If you can show that it was for a different purpose other than Medicaid in a fair hearing, then you can still qualify. And you have to go through those things lots of times. Luckily, Kansas starts out only asking for a few months of bank records for Medicaid, whereas some states actually ask for 5 years of bank records for every account that you had during that 5 years. Kansas doesn't start out with that, but if they see, they will look through the bank account records and they'll say, what was this? And then they'll say, what was this? I want you to give me documentation of what this was. And the lady I work with, she knows this stuff. Okay, so then the Medicaid comes out with a list, and they send you the list. We've looked through your records. Thank you for providing them. Now we have this list of 1 million things that we would like you to provide us, and you have 10 days. Okay? And the 10 days is serious. And then sometimes you can get an extension on that if you know what you're doing and call them and ask for the extension. The group that I work with, I could not, yes, I could if I put my energy into it, but I'm not going to because it's not my thing. She's awesome. Her group is awesome. And they look through your records and they say, oh, Medicaid will want this record supporting this and this record supporting this. So before you apply, you've got all the supporting documentation that Medicaid would have asked for, and so it just goes through. She's awesome. Worth every penny. So, oftentimes the person who's your predator, the person who will end up taking your stuff, is the person who's sitting next to you. They didn't mean to, but they will anyway. Okay, so let's look at a spouse. You guys are young, Dale. Okay. If something happens to you, Sarah's young enough, she'll probably remarry, right? Okay, let's say that you have more money than you do. Okay, when you die, your money goes to Sarah because you love her, right? We'll ignore the fact that I've told you don't do that if you love somebody. Now, what happens if Sarah goes into a nursing home? Is your money safe? No. They take Sarah's money, they take your money because you gave it to her. Okay.
And she's remarried.
Well, we haven't done that yet.
Oh, okay.
We haven't done that yet. Okay. Now we'll do that. She gets a new friend. All right. Now who's in control of Dale's money?
The new friend.
The new friend, maybe. Yeah. Okay. Dale probably wants his money to go to his children, but Sarah's having so much fun with her new friend in Cabo that a lot of that money is now gone. And maybe her new friend wants to open a car lot. Dale's money was just enough to do that.
That has happened, yep.
Okay. And this is all because Dale loved her and gave her the money. Okay. Don't give her the money, Dale. She didn't get to hear it. Okay. So we talked about the nursing home also. Okay, what about the kids? Oh, let's talk through all the things with the kids. So your kids are little. We don't know about them yet. So spendthrift. Anybody know what that is?
Spender.
Yeah, that's right.
Loves to spend.
You give them $1, they spend $2.
Yes.
Okay. I had a lady I really respect call me and tell me her wonderful daughter, whom I knew and respected as well, had a shopping addiction. And that addiction had driven her to open up a $30,000 credit line under her mother's name and blow it all.
Yikes.
And when she was talking to me, we were preparing for me to tell her who to contact to prosecute her daughter criminally. And then she called me back and she said, you know what, I'm going to handle it another way. I just don't feel, as I've been praying, I don't feel like that's the way that the Lord wants me to handle it. And so she handled it another way. But that is real. Bankruptcy. Some kids are dumb. Some adults are dumb. And if those adults happen to be your kids and you gave them the money and they've already been through bankruptcy 3 times, well, that's hard to do now because it's 10 years apart. But, okay, so 2. Don't be surprised if your money gets lost too. Okay? Addictions, well, we talked about shopping addiction, but there's a lot of other addictions. No, a reason to talk about this actually is not just the money being gone. If you want to kill a child who has an addiction, give them money. Right now, life keeps them in check. And maybe they just, go to the bar a few too many times, or maybe they have a friend who supplies some stuff that they think makes life fun. But you give them a bunch of money, and the next thing is cocaine. And then, and then you're paying for a funeral. Okay? So don't give your kids your money if you love them. Okay? We talked about this, the 2-finger test. You don't know if you're going to have disabled kids or not. But what happens if grandma says, little Joey has Down syndrome, I just want him to have something, he's such a sweet boy, and grandma leaves him $25,000 in her will because she didn't come see my workshop.
Needs a trust.
Yeah, he needs trust. But she didn't leave it to him in trust, she just gave it to him in the will. What happens? He's been in the group home for the last 16 years, and now, first, Medicaid says, oh, you have money, we're not paying anymore.
We're going to take that.
And then now all the money grandma left for him is paying for the group home and any other medical needs he has. And then we go back and apply for Medicaid again because we're broke. She loves him. Don't give it to him. Okay? Divorce. Now, this is not you getting divorced. Okay, so, Sarah, we played around with you a little bit when you were gone. But now we're not playing with you. Let's talk about Clara and her new friend. Clara's their daughter.
Okay.
She's not allowed to have friends like that.
Okay, so Clara gets a new friend. He is dreamy, and you hate him.
Yes,
Okay,
very much so.
and you live a lot of years, and she doesn't talk about their relationship much, but you still hate him. And then you die, and you give the money to Clara. And what does Dreamboat do? He says, Clara, I have another new friend. Here's my divorce papers. Send me a check for half. Did you mean to give your money, half of it anyway, to Dreamboat guy you hate? No. Okay? So don't give it to Clara. That's not the best way to handle it.
So if it's in a trust, you have to follow what the trust says, correct?
Yes. What time is that? My eyes are not working. It says 3:20. Okay. All right. Let's see. Oh, financial aid. Oh, so this is a good one too. So you are all going to live a long, long time, hopefully, right? You are now, Dale and Sarah, 80. Clara's 50-ish. I don't know where she is. Okay. Clara has 3 kids who are in college or graduate school. You die. You've had a really good life and you've built up a lot, and you are so happy that it can now bless your children. And so a whole bunch of money goes to Clara. Now what happened to her kids? They are all disqualified for financial aid. So don't give her the money if you love her, or if you love the grandkids. Because then what has to happen is then they have to pay for the school if they want it, which means the money you just gave them is going to go to the schools. So let's go over who's in control. Okay, so there's 3 phases of life from an estate planning point of view. There's alive and well. There's alive and not well, meaning you are mentally incompetent. And then there's dead. Okay, so let's look at your stuff while you're alive and well. Who is in control? You are, right. Who gets the benefit of your stuff? You do, okay? And when? Whenever you want, okay? Now, we had you guys in a car wreck earlier, right? You got in a coma. Sure. Okay. Let's put you back in a coma again. And so, who's in control of your stuff now? Well, maybe a spouse, maybe somebody who applies for guardianship and goes through guardianship proceedings. Or if he has a power of attorney, then that person. Yes, okay. And who gets to benefit? He does, still. That is the plan. Well, if you've created a plan around it, then yes, that's the plan. All right. And what can they do for you? Well, that depends on what your POA says. All right. Now you're dead. So who's in control? Is it the court? I mean, did you do nothing? And so now the people in Topeka have written laws, and those are what controls through the probate court. Or you wrote a will, and now whatever the whims of the judge are, and did you know that you had a daughter somebody who's going to claim to be your daughter in the future? Right. Well, it depends on how much money you have. Okay, so it's the court who's in control, unless you've said it several times, and do what? You have what?
Trust.
A trust, yes, unless you've kept this stuff outside of the court, and it's in a trust. Okay, so next slide. Okay, so what do you want to do? You, typically, clients would say, what we want to do is we want to stay in control. We don't want to be a burden to our loved ones. We want to keep things simple. You won't accomplish this if you try to avoid the pain now by just doing nothing or just using a simple will. Okay? Because then the court will be in control. You will be a burden to your family. And they're the ones who are picking it up. At some point, it stops being about you, and it starts being about them, because they're the ones who are going to have to take care of you in the hospital, put you in a home, and bury you. So, what are you going to do with what you can do if you love them? Option 2 is really making a plan where you can make your own decisions. And you make them now. And then as time goes on and things change, you continue to keep things updated. Now, how would it be if when we went to probate court, you were able to come back and you could say, Judge, this is really what I meant, and this is what I want to happen. And by the way, I never slept with that woman. That is not my child. Okay, wouldn't that be nice? Okay, when all those decisions are made, your estate is called settled. The idea of doing the planning is to settle your estate now and keep it constantly in a settled state so that when you kick the bucket, it's done. There's almost no work left to be done. That's the idea of real planning if you really love the people you're planning for. if you want to do what's best for them, and if you have the funds to do it. Sometimes it's hard. And this is something I struggle with because I have to make a living, but some of the people I want to help can't afford me. And it's just something I struggle with. And so I'm trying to figure out how to get around that. I've had people that I've helped, and it took them 2 years to pay me, you know. It's just like they got a tax return, earned income credit, and they paid me some. I'm going to talk about Medicaid real quick. Okay, so this is a New York case. This is an actual real case for Dave Zampano, the one who made these slides. Mary Smith's sister's son played baseball with Dave's son. Mary calls him, and she says, Dave, you don't know me, but I know you. We've already been to Dad's attorney. We know what to do, but my sister says I can't do anything until I've talked to you. And he said, okay, Mary, what's the situation? She said, well, Dad is in care. He's got a house worth $60,000, car worth $10,000, cash of $105,000, and stocks of $275,000, total of $450,000 of assets. Medicaid would call them resources. And Dave says, well, what did the other attorney tell you? Well, he said that the house and the car were exempt. Yes, they're exempt. He said that she could keep $15,000. New York, right? Okay. Guess what it is here? $2,000. You can keep 2. Okay. So, sorry. This is mom going in. Dad is still okay. Mom's in care. Okay. This is Mary Smith's mom in care. And the cash. Well, what do you say about the cash? You said, said Dad could keep up to, I don't remember what the level was for New York. And he said, well, oh yeah, it was, anyway, there was sort of $15,000 that was going to be left out of that. And what did you say about that? Well, he said that we could pay his attorney's fees of $15,000. And he said, well, what about the $275 in stocks? Well, we have to liquidate those and pay for mom's care for 60 months. And then after 60 months, whatever's left over, we get to keep. Well, care for 60 months, how much of the $275 is going to be left? It's gone. And you paid that attorney to do what for you exactly? Because you didn't have anything left over. Okay, so Dave says, could you fill out a 1-page paper for me? And she says, yes. And he sends her a letter, and she calls him, and she says, what's the big idea? What? I thought you would like my letter. This says that mom qualifies for Medicaid now, and we don't lose any money. And he said, well, yes, Mary, that's right. Why should I believe you? Well, because I put it in writing. Did the other attorney do that for you? So actually, she went with them, and he actually sees, 6 years later, he was still seeing Mary's dad at the ball games. And we in Kansas can't do it the same way they did in New York. Actually, though, we can do it easier when you have a couple. Switch slides. Let's talk about the Richards. Okay, another case. Now, this was a pre-planning case. So that was a crisis case. Mom was in the facility. Pre-planning case. We got $577,000 of stuff. If we pre-plan, it's like taking a crisis plan and starting it early. So what you could protect in a crisis plan is that $449,000. Only $128,000 would be at risk. But once you hit month 37 in their circumstance, everybody's got different numbers, different circumstances. In their circumstance, once you hit what we call the break-even point at 37 months, you're able to protect an additional, in their case, $3,500 a month. Until at 60 months, it's all protected. Okay? But we could protect the $449 now and see how far you get. That's what pre-planning does. So how do we protect our stuff? We've been talking about it. So when attorneys talk about trusts, trying to explain them, they explain them as boxes. okay? Here's an open box, here's a closed box. Boxes are boring. So Dave decided to start talking about little red wagons. It's a little red wagon with instructions, and you put all your stuff in it. I didn't have a little red wagon. For me, it's a cookie jar, right? What do we have in the trust here? Oh, there's the pins I was looking for. All right, we got some money. We've got our house. House goes in the trust. The money goes in the trust. Pets can be taken care of in the trust. Car goes in the trust. We have a farm. Okay? That's a cow. And there's a fence. Okay? We have a farm. I don't want to put the farm in the trust. Nope. I've got something else here. All right. This is LLC. All right. We're putting our business, we're protecting that. And then guess what? Put the business in the trust. Oh, land. Okay. I'm going to teach you a little bit about the history of trusts. Who knows the story of Cinderella? Okay, the really tragic beginning part. What happens to Cinderella's dad?
He died.
What was he doing when he died? He was away on business.
Oh, that's right.
Right? He was away on business. So it used to be when you would sell land to another person, we're talking way back, right? There was something called livery in season. And they would have this ceremony. Sometimes they'd call it passing the clod, where you'd hand over a piece of your land. Here, Sarah, I'm going to hand you a piece of the land.
I'll take it.
Now,
It's fine.
2218 East Bryant Street is yours, okay? This completes the bargain. All right. Then, it wasn't that I was wanting to pass the land off forever, but I'm going to be away on business for a long time. So I'm going to pass my property to you to take care of for me. And you are now responsible for taking care of my family as well. I've given it all to you to take care of. You are now what? What's the term? The trustee. Okay? So that's kind of how it all started. So we put the land in there. Do we put this on? No, because this is a revocable living trust we made while we were alive. See that open box right there? Okay, we can put stuff in, we can take stuff out, right? If we can take this stuff out, though, who else can get it? Our creditors and predators can. As long as we can get it, they can too. They can step into your shoes for the purpose of taking your stuff if they have a legal right to it. Okay? Okay. So, what do we do to make it where they can't get it? Well, we have to make it irrevocable and make it where we can't get it. We'll talk about that a little bit more. First, let's talk about irrevocable trusts. Does anybody know what an irrevocable trust is? An irrevocable trust. Now, when I started, remember I said that I became fascinated with making sure people didn't give the government estate taxes? We were working on, whoops, I got it backwards. These things right here, the closed box, irrevocable tax trust. Okay, with that, you had no control. You could get no benefit, and you could not change it at all. But you had tons and tons of assets, and you were trying to get them out of your estate so the government didn't take them. You were trying to find ways to pass them on to the next generation. That's not the case so much anymore, right? So this trust, you couldn't do this stuff with. But if we're not worried about the taxes, then we can put other provisions in there. In fact, we put other provisions in there to make us have tax on this stuff on purpose. And this is why. Do you have a house?
Yes.
Good. Otherwise, I would have just told you you had one. Okay. You want to pass that on to your children. Okay. But you're not going to give it to them. Okay. You're not going to give it to her. Okay. But you want it to pass to her. If you give the house to her now, whether it's outright or it's in a trust, if you make that gift now, she gets something called carryover basis. I'm just going to say you paid $10,000 for the house, okay? And it's going to be worth $1 million when she decides to sell it. How much income does she have? Well, $1 million minus 10, right? Okay, what if it's included in your estate, you don't give it to her now, it goes to her because you died? Then what happens if it is taxed to you? See, this stuff, this was moving it out of your estate before you got taxed. We want it to be taxed to you because it's only $1 million. That's nothing. Because you got 12.92 of a unified credit. Okay? So the IRS comes to you and says, we're going to tax your estate for $1 million worth of house. And you say, whee, because now they've raised the value of the home to $1 million, and you give it to your daughter at $1 million, and she sells it and has no profit, but she has $1 million. So we do that on purpose. We totally flipped things because this unified credit got so big. Have you ever heard something called step up in basis? No, I see the blink clicks. Okay, do you know what basis is? Ever bought a stock?
Yes, okay, yeah.
Okay, when you buy the stock, the price you paid is your basis.
Okay.
Okay, when you sell it, it could be higher, it could be lower, and let's assume you're profitable, they take whatever the selling price was minus what you paid for it, which is your basis. Okay, you die before you sell that stock. The IRS comes in and your kids say, oh, she only paid $10 for it. The IRS says, no, it's worth $1 million. And so they tax your estate at $1 million, but you have a unified credit that covers that, so nothing comes out of pocket. But they taxed you at $1 million, so now when it passes to your kids, they get it at $1 million basis, like they paid $1 million for it.
Right, how do you get around that? Because I've heard that.
No, that's good. Because if they paid $1 million for it, and then they sell it for $1 million, did they have any profit?
Oh, okay.
No profit, no tax.
Right. Oh.
All right, so let's talk about this trust. All right, I've got my LLC in it. I'm going to use just the money. Okay. We won't make a thing out of this, but we're going to pretend you two are married. Okay? You have a joint trust, the cookie jar, it has money in it. Okay. So, Merle, she's your wife, you love her, but you're about to be dead. We're going to kill you off again. This is a subtrust, and we'll talk about what it's. Yes, it's a trust that's created under the original trust you made. Okay. Let's see. All right. So you're married. All right. Who has the money? What can you do with it?
Whatever we want.
Right. You can spend it. You can save it. You can give it away. Whatever you want. Okay. You have complete access to it. Who else has access to it? Creditors and predators with legal claim against your stuff. Okay. So if you go into the nursing home, is it safe? Nope. No. Okay. This is Merle's. Yeah. This is Martha's. Yeah. He dies. He leaves it in here for her. What can she do with it?
Anything I want.
Anything you want. Aren't you happy?
Yeah.
All right. You have complete access to it. Who else has access to it?
Right.
Okay, if you go into the nursing home, what happens? They're going to say, oh, well, before Medicaid starts paying, look, we see you have this money. We'll say that's $200,000 instead of just $2. And we say you have this money, and we're going to take that. Okay? So, is that the best way to deal with it? Maybe not. Ooh. What if we make it an irrevocable trust? Would you like that?
I don't know.
Well, who can get at it?
No one.
Well, it depends. Who's the trustee? Let's make you the trustee.
Oh, then, yeah, sure. I like
Okay,
that idea.
you like that? Okay, so you can get at it, right? Okay, so who else can get at it?
Nobody else.
Creditors and predators. If she can get it, they can get it.
Too, yes.
Yeah, okay. So that's not working really well. What if we do this? When Merle dies, a subtrust is created. Okay, we'll call one the decedent's trust and one the survivor's trust. That's an easy way. We don't call them that in a lot of trusts because we have more happy terms. Like we call it the family trust and the marital trust. Okay. So this is what you're living off of. Okay. Who can get at it? Well, everybody. Everybody who has legal claim against your stuff. So you can do whatever you want with it. Okay, so let's say now you go in the nursing home and they say, okay, we see you have this dollar. We're going to take that. And we see you have this. What happens? Well, they can't get at that because you can't get at that. You know why? Because I just gave you 2 kids. And one of them is your co-trustee. Okay? And you say, well, Merle left this to me, but he said I couldn't have this stuff unless my daughter, what should we call her?
Put another M in there. There we go.
Mary.
There we go.
Mary and Martha.
There we go.
All right. So Mary, so let's just call her up. She's a good kid. She takes care of things that I need taken care of. I'm sure she'll be fine with it. So we call up Mary and we say, hey, Mary, I need $10,000 out of Merle's trust. And Mary says, what do you need it for? She says, well, we have to pay the long-term care facility. And what does Mary say? She says, no, I'm not going to release it for that. And what does Martha say? She says, darn kids. So is this money protected? Yes, it is. It's protected. They can get at hers, but what he left for her is protected. They can't get it. Okay, now she didn't go to the nursing home. She got in a car wreck and somebody sued her. Same thing. They can get at hers. They can't get this unless Mary says so.
I understand. My parents did exactly this.
Good for them.
Yeah, they did exactly
Good for them.
And it was wonderful.
Okay. Let's see. Okay, now Martha has a new friend. His name is Biff. Biff. Well, when Merle died, he used to clean the pool, and she doesn't want to clean the pool, so she hired Biff. And Biff cleans the pool in a Speedo.
Of course he did.
Okay? And they've become fast friends. They found out they have lots in common. And Biff says, hey, let's go to Cabo. Well, okay. Actually, let's back up. We haven't met Biff yet. So you want a new car. Let's do that first. We'll degrade later. You want a new car. You feel like you need a
Red convertible.
okay. You want a new car, and you call Mary. And by the way, you have another kid as a son. What should we call him? Mark. It's an M. That's mine. Okay.
Mark and Mary, yes.
Okay. So you call Mary and you say, hey, Mary, I need $10,000 from Merle's Trust. And she says, why? And you say, I want a new car. I need a new car. This one's really old. She says, no, the 1975 Dodge Dart is great. You get extra breeze through the rust holes. No, Mom, you can't have the money. Use your own stuff. And while I'm living off of that, this is an extra expense. I want the money for the car. She says, no, Mom, I'm not going to give it to you. And you know what you can say? The trust says you can say 2 words to Mary. The 2 words are, you're fired. Now, who do you call? You call Mark. Okay. So you call Mark and you say, Mark, I don't know what I'm going to do. I just had to fire Mary because you wouldn't let me have the money to get a car that I need. And he says, well, Mom, I think you ought to be able to drive a Cadillac. And you say, what do you say to Mark? How would you like to be my new co-trustee?
You're hired.
That's right, you're hired. Okay, now let's go to Biff. Okay, because I had to have that so we can show a dichotomy. Okay, so now we got the car, okay, and we have our new friend Biff. And he wants to go to Cabo. And so, Mary, you call Mark now, because she's gone. So you call Mark, and you say, hey, Mark, you were so good to me with the car. I need $10,000 more. Well, why? Well, because I want to go to Cabo with Biff. And he says, no, Mom, you have your own funds to be able to go have fun and do your own thing. These are supposed to be for extra needs and eventually to come down to us. Dad put them there to protect them for us. And, as long as you're taken care of first. So I'm not going to release the funds for you. And she says, you're fired. And he says, oh, Mom, you got to read a little bit further. Dad said in his trust that if you get remarried, you can't fire me. And you say, well, I'm not married to him. I was married to your father for 50 years. That's enough. I'm not doing that again. We're just going to have fun. Well, Dad defined remarriage as cohabitation for one night. Okay, so you can define this stuff. A trust is a contract, okay? And a contract, as long as it's not in violation of public policy or law, you can come up with other crazy stuff you want to do as long as it works. So what happened? We started out with pass the clod, take care of my place, and then somebody would come up with a problem, somebody would come up with a solution, somebody would come up with another problem, there's another solution, and now our trusts are this thick. If you want that thick, it all depends on what works for you. Okay, so now you've both died, and who gets these? Mark and Mary. Okay, each of them have half, and the lids are on. What does that mean? They're protected. Okay, so who's the trustee?
Mark is the trustee of Mary's, and Mary's the trustee of Mark.
Ooh. What do you think? Go ahead.
No, I don't know.
Mark is the trustee of Mark's, and Mary is his co-trustee.
And vice versa.
Mary is the trustee of hers, with Mark as the co-trustee. So Mary says, hey, Mark, I want to get at some of the money Mom and Dad left me. I want to buy a condo in Florida. And Mark says, no, Mary, I'm not going to give you the money out of the trust for that. And she says, do you want me to fire you? No, just listen for a second. You don't have to fire me. Instead of you pulling it out, you should have the trust buy the condo. Keep the condo protected inside the trust.
Oh, that's why.
And then you can live in it because you're the beneficiary of the trust. So that's what they do. We go on for a while. Mary has been married for a long time. She retires, her husband retires. She takes up gardening. He takes up golf. His favorite hole is what? The 19th hole, which is the pub, right? So he's been golfing for a while. He comes home one day all excited. I really should have taken up golfing a long time ago. I want to tell you all about my new best friend. And Mary says, well, tell me all about him. Well, her name is Bambi. She was the barmaid. And she keeps on bumping into me. Finally, I introduced myself. And we have so much in common. We're going to get tattoos. We're buying Harleys. We're going across the country. Here's my divorce papers. Send me half.
Oh my gosh.
Does he get half of the condo? No, because it's not Mary's. It belongs to the trust. It says integrate up there. Every attorney calls this funding, putting stuff into your trust. Integrate has another term, another connotation, which means that you're making all the pieces work together. Okay, but see, we have these two trusts here. I'm going to try to get these back without breaking them. Okay, so I'm walking along in life, and I have a house, and I have a car, and I have my pet, Pooch, and I have some land, and I'm walking along, and I trip over something, and I'm in a coma. What happens to my stuff? Am I holding on to it anymore? No. It's probably all over the ground, right? Okay, all over everywhere. So who picks it up? Well, who has authority to pick it up? Well, nobody, unless I've given somebody authority. We start out with, well, do I need a guardian to pick it up? Have I given somebody a POA? Okay. If I've given somebody a POA, what can they do with it? Well, it depends on what's in there. If I have the right type of POA, it will tell them, put that stuff in my trust. Okay. What if I went ahead and put it in my trust first, before I tripped? That's what you should do. Okay, you've got to put the stuff in your trust. How do you do that? I didn't know this coming out of a law school. It took me practicing a little bit to even realize what was going on. You take the title of your house, you write a deed that says, I give this house to my trust. Boom. You go to the DMV. You say, I want to retitle my truck to my trust. Boom. Pets don't have title. They're personal property. What do? We write a document that says, I hereby put all my stuff in my trust. Jewelry, clothes, pets, whatever. It's in there. Anything that doesn't have title is now in my trust. Bank accounts have title. I go to my bank. I say, I want to retitle my account to my trust. Please keep the same number, keep my checks the same, just title it to the trust. And now, I don't own any of this. The trust does. And who is in charge of the trust? Well, me, right? Yeah, until I go. And then I have instructions on who takes over next. And do we split it out into a baby trust and keep some here? You know, it depends on what the needs are. Okay, so now I'm walking along and I have my trust. Maybe a glass jar wasn't the best thing. Now I'm seeing the wagon. Okay, but if something happens to me, I fall, the trust is still here, and the trust has a bunch of instructions that says this is what we do with all of it. That's why we use trusts, is because they're so much a better vehicle to take care of so many things. You remember what I said about the idea is you settle your estate now and you keep it settled? I had one that didn't work.
They didn't consult the expert.
I'll tell you why.
Put it online.
I'll tell you why. Because it wasn't maintained, or because they didn't follow the rules that they were supposed to follow. So in my case, It was a banker husband and a stay-at-home mom, retired because of all the kids grown up and moved away. She's taking care of her husband now because he's getting dementia. But he's lucid enough to sign the trust. Okay? I have an interview with him. He understands his property, knows what's going on. We do it. I get a call from her son, who's an attorney. And he says, why weren't these oil rights put into the trust? And what are you going to do about it?
Nothing, I can't.
And the answer was, we talked. I gave her a whole packet of funding instructions. She wanted to fund the trust herself. She got everything else in there. She missed it. Sorry. $12,000 probate for the one item she missed. That burns me. I was trying to save them money by not taking care of the funding myself. If I'm going to spend the time doing the funding, actually I have somebody else who I'll hire now that's what they do. But it costs money, and I try to save the money if I can. But that's one of the reasons, okay? They just don't follow what needs to be done. Another reason is we did this thing and then we forgot about it. We walked away from it, okay? And life went on. Kids grew up, got married, got divorced, whatever. Every now and then we think about this, we think, maybe we ought to update that. Okay? And then the car crash, and it's still not been done. So it doesn't work the way you wanted it to because things have changed. The Secure Act changed all kinds of IRA planning and trusts of 2019. Okay? Laws change. Your trusts need to be updated. That's why we're talking about maintaining your plan. To make sure your plan works, you have to act. And he gets gimmicky here and makes ACT into an acronym. But this is true. Okay, this is cheesy, but it's true. You came here because you know this stuff's important. Doing it's painful because it's pricey. And even if it wasn't pricey, sometimes it's painful because it's emotional to think through these things. So people avoid it. But if you continue to avoid it, then you die with the government's plan. Okay, next. Okay, so this is what would happen if you had a vision meeting with Dave Zampano or me, which would be we analyze your stuff, we go over what the possibilities are and what you want, and then you make a choice. Trust protector can be the same thing by a bunch of different names. The trust I was hired to analyze the other day called them a special co-trustee. But when I read what their powers were, I'm like, that's a trust protector. Okay, so you give the trust protector powers to fix things. You give the trust protector powers like, hey, you can boot out a trustee who's lost their marbles, and you can replace them. Okay? If the law changes, you can change the trust to bring it into compliance. There's something called decanting. We have a shiny, brand new decanting statute in Kansas. I've been waiting for it for 15 years, which allows you to take an irrevocable trust with the lid on that can't be changed and change it. Very cool, actually. When you run into problems, I have 2 cases already I'm using that statute on. It's a valuable thing. You can give the trust protector authority to decant. So if something in this trust isn't right for the new circumstances that have come about, as long as it doesn't violate the intent of the trust, then they can make a change. Yeah. Yeah, there's some good things that can be done if you know about them. And that's the thing. It's just that, did anybody grow up and watching G.I. Joe? Was knowing is half the battle? I really wish I could get this message out to people because they think that they know what's going on, and what they need to do, but they're wrong. All right. Thank you very much.